We are ready, Shad.
Okay. Good evening, everyone. Thank you very much for joining us this evening. My name is Shahid Hamouri, and I'm joining you from Amman. And it is indeed an honor to be moderating this wonderful panel with colleagues and friends. So at the beginning, I will say a few words in Arabic in order to indicate for people the interpretation option available. مرحبا الأعزاء المتابعين باللغة العربية. هذه الندوة ستكون باللغة الإنجليزية. هناك ترجمة فورية إلى اللغة العربية. يمكنكم الاستماع إلى الترجمة العربية من خلال النقر على الأيقونة على شكل الكرة الأرضية أسفل الشاشة الزوم واختيار اللغة العربية في فقرة الأسئلة والتعليقات. يمكنكم طرح أسئلتكم وتعليقاتكم باللغة العربية وسوف يقوم المترجمون بترجمتها. للمتابعين عبر اليوتيوب سوف تستمعون للندوة فقط باللغة الإنجليزية. سوف يتوفر تسجيل للندوة مع الترجمة الفورية باللغة العربية على موقع منظمة القانون من أجل فلسطين مع نهاية الأسبوع وشكرا. Back to English. Welcome everyone. And thank you very much for joining us this evening and for your interest in the subject matter. My name is Shahid Hamouri, and I am a lecturer in international law at the University of Kent. I am a specialist in international law and war economies, and I've worked quite extensively in relation to the case of Palestine, specifically most recently. And I'm also a senior legal advisor at Law for Palestine. Before we begin, I'd like to just note a few logistical points for our discussion today in relation to Law for Palestine. Just briefly announcing that there is a new season for the Jurists for Palestine Forum. We will be shortly sharing the link on the chat here. And we also want to encourage members to join in the membership of Law for Palestine. This season of events at Law for Palestine is conducted in partnership with ICHR, who we thank for their partnership and support. And this is just a reminder, of course, we do have the simultaneous interpretation in the Arabic language. Today, we are here to discuss the legal implications of the ICJ's decision that came out in July in relation to the illegality of the Israeli occupation of Palestine. What we had is a historical decision by the International Court of Justice that came out of after decades of work by allies and Palestinian international lawyers who have worked towards the very, very simple conclusion of declaring the prolonged occupation of the occupied Palestinian territories as illegal. As you're very well aware, the court came to this conclusion and said that the Israeli occupation of Palestine needs to end as rapidly as possible. The court also affirmed what we have known for very long, is that Israel is committing violations of the USCOGIN's prohibition against the violation of the Palestinian people's right to self-determination, as well as the prohibition against aggression, as well as the prohibition against all forms of racial discrimination, including the prohibition against apartheid. In this historical moment, as we are also discussing this with heavy hearts as we see and witness the ongoing genocide in Gaza. This is a moment of historical significance for the Palestinian people and also for the international legal system as a whole. It opens up very big questions about the enforceability of international law, the exceptionalism of international law, whether or not we can have an international legal system that speaks in principles of justice. What we are hoping to do today is to bring forward a narrative of what needs to happen if we are to take this decision forward. This decision comes from the highest court in the international legal system, and it does indeed bear the most significant of legal consequences. That if we are to see them taken forward, we need to see this happen by civil society actors, by activists, and by people who are willing to take forward the sound of justice in the international legal system over the sound of politics and the aim to limit this framework. Of course, to discuss these very important legal implications with us today, we have an esteemed panel of academics who have worked quite closely on the subject matter, and it is indeed an honor to be introducing them. If I am If I'm correct, perhaps we will be starting with Victor, if I'm not mistaken. If you don't mind, Victor.
No, it's fine. That's fine.
So each panelist will be speaking from 10 to 12 minutes. I will be notifying them almost 10 minutes into their talk. Uh, um, Dr. Kattan is an assistant professor of public international law at the University of Nottingham and the deputy director of the Nottingham International and Security Center. He is also a member of the editorial board of the Asian Journal of International Law and is an area editor for the Middle East and Islam for the Oxford Bibliographies of International Law. Dr. Victor has worked quite closely on the case of Palestine for long years and is indeed one of the most important voices to share with us his positions today. He will be addressing the legal tools for enforcing accountability and dismantling apartheid frameworks. Dr. Victor, the floor is yours.
Thank you very much, Shahad, for that kind introduction, and good evening, everyone. So I'll begin my remarks by briefly introducing the definition of apartheid in international law and how Israeli policies meet that definition. Then I will discuss the General Assembly resolution that was passed following the ICJ's historic advisory opinion, and particularly a recommendation to look into new anti-apartheid frameworks, which the United Nations Secretary General is currently reviewing. And if I'm correct, I understand that those proposals are to be, or the report at least, is to be issued at the end of this week. So let me begin with the way in which international law defines apartheid. So under international law, apartheid is defined as a crime against humanity. So although it's also considered a violation of human rights law, it's not actually defined in human rights law. It's only defined in international criminal law. And the way it's defined is it's associated with a structure of government in which a superior racial group establishes a system that oppresses and dominates an inferior one. And in order to ensure the maintenance of such an oppressive system, multiple inhumane acts are perpetrated. Now, there are two conventions that define the crime of apartheid. They largely overlap, but there are some differences between them. The first convention is the 1973 International Convention on the Suppression and Punishment of the Crime of Apartheid, which has 110 states parties, all global South states, with South Africa acceding to the convention earlier this year. Then there's a 1998 Rome Statute of the International Criminal Court, which has 124 states parties, many of which are Western states that are not party to the 1973 Apartheid Convention. The state of Palestine is party to both conventions, and it won't surprise you to learn that the state of Israel is not party to either of them. However, it can be argued that the crime of apartheid, the crime against humanity of apartheid in international law, reflects what we call customary international law, because according to my own tabulation, around 167 states have ratified at least one of these multilateral conventions. So there's a case to be made. And perhaps later in my comments, I'll explain that despite the customary international law status of the crime isn't so important when we consider that, for example, the situation in Palestine is currently under investigation by the Office of the Prosecutor of the International Criminal Court, who has explained that they are still investigating West Bank crimes, and this may include the crime of apartheid. But perhaps I can say more about that in the Q&A. But to return to the way in which apartheid is defined as a crime. So I mentioned that both definitions in the Rome Statutes and in the Apartheid Convention refer to what they call inhumane acts. Now, the 1973 Apartheid Convention is broader. So it doesn't just include what you consider crimes in ordinary law, murder, genocide, torture, persecution, forced labor, but it also includes more classical violations of human rights, discrimination, restrictions on freedom of expression, restrictions on movement, residence, occupation, and the right to work, etc. But it's the context that's important. So these crimes have to be committed for the purpose of establishing and maintaining domination by one racial group of persons over any other racial group of persons and systematically oppressing them. And a similar definition appears in the Rome Statute, but due to time, I won't be able to go into that in so much detail. The important thing to, I guess, to remember is that under the Rome Statute, the inhumane acts are limited to pure crimes against humanity. So it's not as broadly drafted as the Apartheid Convention. It doesn't include human rights violations as inhumane acts. As regards to whether Israel is committing the crime of apartheid, I would note that in its advisory opinion, earlier this year, the International Court of Justice opined that a broad array of legislation adopted and measures taken by Israel in its capacity as the occupying power treat Palestinians differently on grounds specified by international law. The court illustrated this by referring to multiple examples. And these include restrictions on the exploitation of natural resources by Palestinian enterprises in Areas C, discriminatory legislation, discriminatory ID card and permit system, territorial fragmentation, restrictions on freedom of movement, and colonial era legislation justifying the demolition of Palestinian property. The ICJ explained that the differentiation of treatment could not be justified with reference to reasonable and objective criteria, nor to a legitimate public aim. It expressed its view that the regime of comprehensive restrictions that Israel imposed on the Palestinians constitutes systemic discrimination based on inter alia, race, religion, or ethnic origin. And then it found that there'd been a breach by Israel of Article 3 of the International Convention on the Elimination of All Forms of Racial Discrimination, which refers to obliges states to prevent, prohibit, and eradicate all practices of racial segregation and apartheid. So I've argued in my own work, in my own writings on the advisory opinion, that this reference to systemic discrimination is curious because the definition of, so although the court doesn't go into a lot of detail, apart from some of the judges in their separate opinions, they don't go into detail on what they understand by apartheid. I would argue that systemic discrimination is simply a synonym for apartheid. And when you look at the definition of apartheid in the Apartheid Convention, the Rome Statute, it's defined by its very nature as a systemic crime. Crimes against humanity are widespread and or systematic, and I'd argue that they're both in this case. And so it's important to understand that the definition of apartheid in international law is broader than its popular meaning. So it goes beyond policies of segregation and separation to include domination and oppression. So a strong argument can be made that the ICJ found a breach of apartheid, but was out expressly qualifying it as such. And before I jump into talk about anti-apartheid framework, I'll notice that some people raise the issue of whether Palestinians and Israelis are racial groups. And I would just, in my own work, having reviewed the racial groups as defined in the law of genocide, international human rights law, the laws of apartheid South Africa, and in the domestic penal legislation of states parties to the 1973 Apartheid Convention, we can see that states have interpreted racial groups not only by race, but also by nationality, ethnicity, and religion, and even in some cases by language and culture. So obviously these categories would cover Israelis and Palestinians. Okay, turning on to what the kind of anti-apartheid frameworks. I think it's worth recalling that during the Cold War, the United Nations Security Council was similarly deadlocked over the issue of apartheid in Southern Africa. And so what the anti-apartheid diplomats, activists, and human rights scholars groups did is that they created mechanisms, whether civil society or even governmental mechanisms at the United Nations to nonetheless put pressure on states to sever their relations with South Africa. Probably the best known one is the Anti-Apartheid Committee that was established by the United Nations General Assembly in 1962. And what's significant about that body, and I believe this is one of the this is something that the United Nations Secretary General is looking into. What was significant about the special committee was that it was a permanent body. So although it was more costly being a permanent body, it was more effective. Its mandate could also be tailored to focus on only one country, which might be attractive to some countries. The problem with the other proposal, which is the treaty monitoring body of the 1973 Apartheid Convention, is that it could apply to any it could review the practices of any of the state parties. And so I suspect that the Anti-Apartheid Committee is what the United Nations will be focusing on. So what that body did is it provided a space for transnational and international anti-apartheid networks to come together. And it adopted a very combative tone from the start, openly supporting coercive measures against South Africa, such as arms embargoes, trade embargoes, and closing diplomatic missions. It also established civil society monitoring mechanisms to monitor compliance with embargoes, because they didn't trust that states would monitor these sanctions themselves, or there'd be loopholes that they would try and get around. A quick word on the other body, the Apartheid Convention's treaty monitoring body is worth considering. There's no harm, I guess, in having two bodies, but in contrast to the Anti-Apartheid Committee, it only met once a year for 5 days. It was mostly comprised of diplomats as opposed to independent experts. Yeah, and so it was more limited. It was obviously limited to reviewing the way in which apartheid was defined in that convention. Perhaps I should say something about the kind of things that an anti-apartheid committee could do if before closing, if one were to be established. So I mentioned 2 minutes. I'll be done before. I should mention that I think Al Haq actually has recently published. Dr. Ralph Wild has recently published a study looking at the kind of steps that third states can take against Israel to enforce compliance with international law, especially for breaches of peremptory norms of international law. And he basically argues that it's very hard to differentiate and distinguish between what Israel proper and the occupied territories, and so he's kind of called for a complete reciprocal embargo, including arms, but also covering finance, investment, scientific, technological, audiovisual, cultural, and sporting embargoes against Israel. So I can't really deal with it's a very in-depth, detailed study, which I think is online. So I recommend reading that. But I think that's the focus of where activity should be going. A specific focus, for example, could be in the UK. The trade agreement was Israel, and with the European Union's association agreement with Israel. The UK has only, I think, withdrawn 30 out of 350 arms licenses. So there's obviously much scope of work to do there. It hasn't said that they won't issue new licenses. And it hasn't said that it won't import Israeli technology. So you should have an embargo should work both ways. And then, of course, I think they've announced some asset freezes for certain Israeli settler groups. And of course, then there's the issue of enforcing arrest warrants from the International Criminal Court. But I'll leave that for the Q&A. So thank you very much for listening to me.
Sorry. Thank you so much for that, Victor. And just for now, we're gonna, sadly, Jinan was incapable of being with us live. Hopefully she'll be able to be with us live in the Q&A. But before I move on to Jinan, thank you so much for that, Victor. Sorry, it is your timer. That is, and before I move on, thank you so much. As we're very well aware, apartheid is significant because of its systematicity. And indeed, as you alluded, when we think about systematicity, it shows us that Israeli institutions are inherently intertwined with the illegalities that are happening. So it means that it's very difficult for us when the court tells us that to differentiate between economic dealings with the occupied Palestinian territories and not. When we think in terms of systematicity, we understand that this is very structured. And when we look at the precedents, we understand that actually the only way or the correct question to ask for state responsibility at the moment is not what are the economic activities that Israel that have to do with the occupied Palestinian territories or not, but rather what are the economic obligations of states needed in order to stop the ongoing illegalities, which is the legal approach that was taken under the apartheid framework. And what we are hoping now to see is further pressure internationally in order to push for the reinstatement of the Anti-Apartheid Committee, as Victor has kindly demonstrated for us as a mechanism of taking that forward and also reviving that very important framework in the 1960s and 70s that captures, let's say, that systematicity of international wrongdoing and enables us to think of it in different terms that go against the very politicized attempt in order to frame the Palestinian issue as simply a humanitarian issue rather than an issue of alien domination and subjugation. On that note, I have to apologize for the interpreters. I myself was quite a bit rushing. And now we're going to listen to Jinan's pre-recorded intervention, and again with her apologies. Before we do that, let me just briefly introduce Dr. Jinan, who will be talking to us about the implications of the resolution for third state parties in severing complicity with the occupation. Dr. Bastaki is an associate professor of legal studies at New York University, Abu Dhabi. Dr. Bastaki is an international law scholar focusing on state responsibility, forced displacement, human rights, refugee law, and citizenship. On that note, can we please play Dr. Bastaki's intervention? I don't think we can hear it. I apologize for that. So I think in light of until we are able to navigate Dr. Bastaki's intervention, perhaps we can go to Dr. Maryam first, and then we will come back to Dr. Bastaki. I hope that the others agree with me. Maryam, are you capable of intervening now?
I am willing and able. I am actually not a doctor. You can call me doctor, but I am not a doctor.
I apologize. It's since I'm in Amman, so the formalities become more formal. Okay, so Maryam Jamshidi will talk to us about mechanisms for unseating Israel from the General Assembly of the United Nations, which is currently indeed one of the most important priorities of the Palestinian civil society engaging with the international community, and indeed one of the most important accountability mechanisms required not only for the case of Palestine, but also for upholding the integrity of the international legal system. Maryam is an associate professor of law at the University of Colorado Law School. She teaches and writes in areas of national security law, public international law, and the law of foreign relations and tort law. In particular, her scholarship focuses on the relationship between the private sphere and national security, as well as the law of foreign relations. In exploring these dynamics, Jamshidi's work draws on political and critical theory as well as sociology. We thank you very much for being here with us today, and the floor is all yours.
Thank you so much, Shahid. It's a pleasure to be here and to be in conversation with all of you about this very, very important topic. So, you know, the July 2024 advisory opinion may not be formally binding on any state, but it makes clear as an authoritative statement of law from the UN's principal judicial organ that mostly as a matter of customary international law, states have certain binding obligations that arise from Israel's occupation of the occupied Palestinian territories. Those obligations on third-party states and the UN include, importantly, not recognizing or aiding, and instead working to end Israel's unlawful presence in the Palestinian territories, which is itself, as has already been mentioned, a byproduct of Israel's breaches of the right to self-determination of the Palestinian people and the prohibition against acquiring territory by force. Obviously, the prohibition on racial discrimination and apartheid are also incredibly important, but those two are going to be the sort of focus of my talk today, the ways in which the right to self-determination and the associated prohibition against acquiring territory by force can be, those breaches can be addressed by third-party states. So when it comes to the right of self-determination in particular, the advisory opinion also notes that third-party states have an obligation to promote that right. So the advisory opinion generally left it to the UN to decide how to operationalize the obligations on both itself and member states arising from Israel's unlawful presence and practices in the Palestinian territories. But it did list some ways that member states can discharge those obligations. The General Assembly subsequently passed a resolution in September, so earlier this year, that reiterates those proposals and details additional members that third-party states and the UN can take to comply with the advisory opinion, some of which Victor addressed in his comments. Other groups have also made recommendations on this score, and like Victor, I commend the El Haq report written by Ralph Wild to everyone on this point. Now, I'm going to focus my discussion on how the UN's power of expulsion, suspension, and unseating of state delegations can be used against Israel and its government. So this is one route for discharging third state and UN responsibilities under the advisory opinion that was not addressed in the opinion itself or in the September General Assembly resolution. But I think it is an important mechanism to consider. So here's the general lay of the land. Under Articles 5 and 6 of the UN Charter, the General Assembly can expel or suspend a state from the UN as long as it has approval to do so from the Security Council. So under Article 5, and I'm quoting here from the Charter, a member of the UN against which preventative or enforcement action has been taken by the Security Council may be suspended from the exercise of rights and privileges of membership by the General Assembly upon the recommendation of the Security Council. Article 6 is about expulsion. It says that a member of the UN which has persistently violated the principles contained in the Charter can be expelled from the organization by the General Assembly, again, upon the recommendation of the Security Council. Now, in addition to these two mechanisms, the General Assembly itself has independent power to unseat the government of a state from the Assembly without requiring Security Council approval. This power revolves around the General Assembly's authority to review the credentials of state delegations, which it can approve or deny. If credentials are denied, the state delegation may not be allowed to take its seat at the General Assembly. Now, while on its face, this power to approve or deny credentials is a procedural one, in practice, it has been used to seat or refuse to seat the government of states which are deemed to be, quote unquote, illegitimate. Now, this situation where a government has been seated or not seated because of its illegitimacy has usually revolved around situations in which there are at least two rival governments vying for the same seat. But it has sometimes actually been used in situations where there's only one government without any rival. This was true for the apartheid government of South Africa, which was unseated using that credentialing process in 1974 until the end of apartheid in 1994. Okay, so how does this all apply to Israel? There are certainly very strong arguments for Israel to be expelled or suspended from the UN under Articles 5 and 6 for its systematic and long-standing violations of UN resolutions, as well as its evisceration of the UN Charter's core principles. But since Articles 5 and 6 obviously require Security Council approval, and because there is no question that at least one member of the P5 will use that veto to protect Israel from expulsion or suspension, neither of those routes are viable options here. The General Assembly's credentialing power, though, is a possible mechanism for removing Israel's government from the General Assembly and partially discharging the responsibility of third-party states under the advisory opinion from July. So the rest of my comments will focus on exploring this route and laying out the reasons why the case for unseating Israel's delegation is particularly strong, thanks to the advisory opinion. So the credentialing process is reflected in the General Assembly's rules of procedure, specifically rules 27 through 29. Under those rules, a 9-member credentialing committee, which is appointed by the General Assembly, considers the credentials of every state delegation to the Assembly at the start of each new session of the United Nations. Once the credentialing committee has reviewed the credentials of state delegations and issued its report, the General Assembly votes on the report. Now, state members can also independently challenge the credentials of other state delegations at any time. And when that happens, the credentialing committee has to consider that challenge, needs to issue a report on the matter, and the General Assembly is given an opportunity to take a vote on the issue. Now, typically, the process for approving the credentials of a state delegation is pro forma. It involves a review of the formal sufficiency of the credentials presented by a state's delegation. That being said, the General Assembly has sometimes looked beyond the formal requirements of the delegation's documentation to examine the legitimacy of the government itself. So, some states and commentators have raised concerns about using the credentialing process to evaluate the legitimacy of a government for purposes of unseating it from the General Assembly. And these critics point to the fact that there are no clear, no binding guidelines for the General Assembly to determine whether a government is legitimate or not. And this lack of legal rules can make the process susceptible to politicization in their view. Some critics also argue that using the credentialing process to unseat a government is basically an end run around Articles 5 and 6, and because of that, violates the UN Charter. In my opinion, and as I have written, the advisory opinion helps to address and resolve both these concerns. It also demonstrates how Israel's government fails the test for legitimacy and should, as a result, be unseated from the General Assembly. So starting with concerns about the legitimacy test. So past General Assembly practice has basically made clear that the legitimacy of a government effectively boils down to its representativeness. So namely, whether or not a government adequately represents the will of the people it controls, and therefore the member state itself. Notably, this was the test that was used in the case of South Africa, which was unseated from the assembly because of its apartheid policies, which discriminated against and disenfranchised its majority Black population. While apartheid was invoked as the basis for South Africa's lack of representativeness, its apartheid practices effectively deprived its majority Black population of their right to self-determination. So in other words, the question of representativeness is a question of whether or not, I got it, the government of a state upholds or denies, right, the right to self-determination that the people it controls hold. So in this case, the advisory opinion, in my view, provides a very solid legal grounding for the legitimacy test and a basis for invoking that test to unseat the government of Israel because of its lack of representativeness and illegitimacy. And it does so in several ways. So first, it clearly holds for the first time that the right of self-determination is both a right, erga omnes, and a jus cogens right. That is the highest form of international legal obligation that states owe to all other states and that all states have a legal interest in protecting. Second, the opinion makes clear that all states, as well as the UN, have a duty to protect and ensure that the right to self-determination is realized in the particular situation facing the Palestinians of the occupied Palestinian territories. Third, and finally, the opinion demonstrates how this legal obligation connects to the question of Israel's representativeness. And in doing so, it sets the stage for the credentialing process to be used as one avenue for third-party states and the UN to effectuate their obligations. So on this issue, the opinion demonstrates that as a part of its denial of the Palestinians' right to self-determination, the Israeli government has prevented them from achieving their own independent sovereign state that could adequately represent their interests. The opinion also underscores the fact that the Israeli government has failed to provide Palestinians in the occupied Palestinian territories with any representation within the Israeli domestic system, where they have no electoral rights, and in fact, few rights of any kind. I know that my time is up. If you're willing to give me another minute, I can go through the Article 5.6 argument. Otherwise, I'm happy to address it later.
It's okay, yeah. Like 1 or 2 minutes is fine.
Okay. So on the argument that unseating a state's delegation violates Articles 5 and 6, in my view, the advisory opinion provides an even stronger basis than already exists for rejecting these claims. So to take a step back, commentators have argued that the General Assembly's power to unseat and the Article 5 and 6 power to expel or suspend a state are completely different, totally separate authorities. And on this view, unseating a state delegation through the credentialing process doesn't violate Article 5 and 6 because it doesn't suspend or expel the state itself from the UN or represent any kind of enforcement action or punishment for violating charter principles. Instead, what it is fundamentally concerned with the representativeness of the state's government. Now, the advisory opinion provides another basis for rejecting arguments about Article 5 and 6's primacy, at least in the case of Palestine. So specifically, the opinion demands that the UN Charter be interpreted in ways that align with the Palestinian people's right to self-determination, since that right is both jus cogens and erga omnes, as the court has very, very clearly held. This means that Articles 5 and 6, which are treaty rules, these are not jus cogens norms, these are treaty rules that are inherently subordinate to jus cogens norms, should be interpreted and implemented in ways that serve, not inhibit, the right of self-determination held by the Palestinian people. The advisory opinion also suggests that Articles 5 and 6 shouldn't stand in the way of realizing this right of self-determination through other established processes and procedures in the UN, say, like the credentialing power. And finally, if there is a conflict between the right to self-determination and Articles 5 and 6, say because a P5 member vetoes and therefore prevents expulsion or suspension from occurring, the UN has to adhere to the right to self-determination over and above the conflicting charter rule. Certainly in this case, and arguably in others as well. Thank you so much for the additional time.
Thank you so much, Maryam. That's really that's really important as we speak. And of course, as you noted, what we are finding now is a push towards a fragmented reading of international law rather than a harmonized reading of international law, which enshrines self-determination and equality as the premises of international peace and security. And sadly, we find that a lot of people and a lot of politicians with their engagement with international law seek to take us outside of that very logical framework, which first and foremost seeks to protect people, and instead focus on a very fragmented, reductive reading of international law that really does evade the point and allow us to and push for a world where the virtue is in power and politics is the one that has the upper hand. And on that note, actually, in relation to Maryam's intervention, it is notable that there was a letter where 500 scholars did ascertain Maryam's points in relation to the importance of unseating Israel, again, not only for the sake of Palestinian people, but for upholding the integrity of the international legal system if we are to maintain any remit of calling for international peace and security. I would like to remind our listeners before we go further of the Q&A option. I see some questions coming in. You're encouraged to point your questions there, and shortly after the last intervention, we will go towards the Q&A session. And also, I would like to note that we will be looking towards the publication of a policy paper in relation to third state economic responsibility in a few weeks' time that further elaborates on some of the points that are being mentioned. So far, we have covered the call for the Anti-Apartheid Committee. We have covered the call for unseating Israel, and now we will be going towards actually ending on a more generalized note in relation to third state responsibility. And on that note, we invite back Dr. Bastaki's intervention. And just as a reminder to our listeners, Dr. Bastaki is an associate professor of legal studies at New York University, Abu Dhabi. We may start her intervention, which will be our last for the evening.
Hi, everyone. I wanted to first start by thanking Law for Palestine for inviting me to be a part of this distinguished panel. I'm going to be speaking about third state obligations with regards to the ICJ's advisory opinion, as well as the General Assembly resolution that came about as a result of the advisory opinion, as well as touching upon the ICC arrest warrants in terms of what are states' obligations. Before starting, I actually wanted to point everybody to a legal opinion written by Ralph Wild for Al-Haq Europe. It's a very detailed opinion on third state responsibilities, and particularly the responsibility of the EU. I encourage everybody to read it. I'm hoping that the moderators perhaps can paste the link to it in the chat for everybody to benefit. So I wanted to first start by saying that the ICJ advisory opinion is incredibly important because it states that Israel's continued presence in the OPT is illegal, that it constitutes a wrongful act, and therefore it entails international responsibility. And the reason why this is so important and perhaps radically different than what we've seen previously is that it doesn't simply critique Israel's practices in the occupied territories in the sense of its violations of human rights law or humanitarian law, or the fact that it is violating the laws of occupation, and that is the problem. So it's not the occupation in and of itself, but just the way that Israel is conducting the occupation. What the ICJ advisory opinion is that it tells us that Israel's occupation per se is illegal. And the court, then went on to state that the General Assembly, the Security Council, they are to pronounce on the modalities that are required to ensure an end to Israel's illegal presence in the OPT, and that all states must cooperate with the UN to put those modalities into effect. Now, even before the General Assembly's resolution that came out afterwards, the court itself gave examples of what are states' duties in regard to ending Israel's presence in the OPT. So of the things that the court kind of considered as the duty of states is to distinguish between dealings with Israel proper, it's the 48 territories, or the state of Israel, and the territories that were occupied in 1967. And so the examples that the court gave are the obligation to abstain from treaty relations with Israel in all cases in which it purports to act on behalf of the OPT, to abstain from entering into economic or trade dealings with Israel concerning the OPT, to abstain in the establishment and maintenance of diplomatic missions in Israel from any recognition of its illegal presence in the OPT, and to take steps to prevent trade or investment relations that assist in the maintenance of the illegal occupation. And so, and when we talk about Israel's violations, Israel is violating what is called peremptory norms, Yuskogans. And states have a specific responsibility when it comes to the breach of peremptory norms. And so states have to cooperate to bring an end through lawful means any serious breach by a state of an obligation arising out of or arising under a jus cogens norm, and that states should not recognize as lawful a situation that is created by a serious breach of a peremptory norm. So in a sense, states are under this negative obligation not to recognize, but also they're under a positive duty to cooperate in order to bring an end to these serious breaches. And even though unilateral measures are not prohibited and states can take their own measures, there is an emphasis on these collective measures, including ad hoc arrangements by a group of states. And so the General Assembly, when it passed its resolution, basically calling for Israel to comply with international law, to withdraw its military forces, and to return immovable property, to allow those who were displaced as a result of the occupation to return. The General Assembly also then cited certain obligations that states have, right? So to take steps to ensure that their nationals, companies, and entities don't act in any way that would recognize or provide aid or assistance in maintaining the situation, to take steps towards ceasing the importation of any products that originate in the Israeli settlements, as well as the provision of transfer of arms, munitions, related equipment to Israel, where it's suspected that they may be used in the OPT, and also calling on states to implement sanctions, right, including travel bans and asset freezes against natural and legal persons that are engaged in maintaining Israel's unlawful presence in the OPT. And so there are a number of things that states now, the third states, are really legally obligated to do. They have to review their treaties with Israel. They have to reassess their relationship with Israel. And I think something that's actually very important to mention here is that the resolution and the ICJ Advisory Opinion, they emphasize distinguishing between Israel's actions in the OPT and between its actions as Israel proper. However, I don't see that we can actually distinguish between them. It is one government, one regime that is perpetuating these violations, that is maintaining the occupation, the economic dimensions of the occupation are linked to the Israeli economy, and there isn't really such a big distinction between Israel as it relates to the 48 territories and the way that it conducts its occupation in the areas occupied in 1967. And I think, and also Ralph Wild mentions this, as I mentioned in his report, and I do agree, that it's very difficult, if not impossible, to distinguish between, when aid and assistance is given to Israel as a state and saying, well, this is only going to be used within Israel proper and it's not going to be used in the OPT. Actually, any kind of aid and assistance is supporting Israel's presence in the OPT. And so I do think that states are actually under an obligation to have an embargo, right, on all of these forms of aid or assistance to Israel, and so I think that this is something very important to consider. Just a small point in terms of the ICC arrest warrants. So obviously all state parties to the Rome Statute are under an obligation that if, Gallant or Netanyahu are on their territories, that they should arrest them and transfer them to The Hague. States that are not party to the Rome Statute, they might not have a legal obligation. However, they are encouraged to do that. So it's not just that states, just because they're not party to the Rome Statute, that they can't do anything. They can, especially if those people are within their territory. They can do that, and so I think that that's something that is important to mention. And in terms of, are there any legal consequences for states that deal with Israel either directly in terms of the OPT or that aid or assist Israel in other ways? I think it's important to understand that they are also breaching their legal obligations. And in that sense, I think that internally, domestically, civil society has an important role to play in order to prevent their governments from these types of illegal actions. And in the international arena, I think what we saw with, for example, Nicaragua's case against Germany. I mean, Germany, again, is not the direct perpetrator that's being accused. It is Israel. But what Nicaragua did is to say that Germany has obligations under the Genocide Convention, and they are breaching these obligations. They might be, complicit in genocide, or at the very least, for failure to prevent because of their assistance to Israel in their assault against Gaza. And so we see that in this case, Nicaragua is taking, its responsibility as a third state very seriously, and bringing Germany to the ICJ in order to reckon with their failure to abide by their legal obligations under the Genocide Convention. So I'm going to stop here. I'm hoping that I'll be able to make it for the Q&A to discuss this further. But just to conclude, it's important to note that third states, they have an obligation. I do not think that it's as easy as saying, well, they should just ban settlement products, which they should. They should have been doing this even before the ICJ opinion came out this summer. I mean, this was already something that is recognized to be illegal. And given the fact that we cannot very easily distinguish between the different dimensions of the occupation and what Israel does in Israel proper, that states actually really have to take a stand. They have to, sever, their economic and their trade ties, as well as their aid and assistance, just because of the entrenchment and entanglement and a lack of distinction, really, between Israel and its actions in the occupied territories. So thank you very much for this opportunity, and I look forward to the questions. Thank you.
So that was that was Jinan, Bastaki, and with a very vital intervention that is very much needed at the moment. So just to reiterate some of the most important points there, which is one, that this decision is not limited to the settlements, and we've seen some efforts to try to limit third state economic responsibility here only to the settlements. And of course, state obligations to end any economic dealings with the settlements have been long established. Here we're looking at the illegality of the occupation as a whole, systematicity, and also at the dependence of the Palestinian economy on the Israeli economy, as is the case in any typical settler colonial economy. And here the mere idea of thinking that we could entangle both will get us stuck in process rather than in substance. And it's very important to always recall what is the point here of third state responsibility. The point of third state responsibility here is to stop a state that is very well intentioned on committing grave illegalities of international law and to protect the Palestinian people against irreparable damage. And here I refer to our listeners the fact that under international trade law, states have a green light in order to violate and not violate per se, but in order not to upkeep their trade obligations with the state of Israel under Article 21 of the GATT, 21 of the GATT. In relation to the application of the UN Charter. And further, the Vienna Convention says that any agreements that are in violation of Jus Cogens norms, which are preemptory norms of international law, the highest level of international legal obligations, which are meant to be protected because they are in violation of the most important principles of international law, are to be considered void. So here states have a green light to review their trade and investment agreements with the state of Israel for the purpose of applying their international legal obligations. As I previously mentioned, we're currently working on publishing reports that will facilitate advocacy efforts towards that end and towards states upholding of the third state responsibility. Also, I just shared in the chat a very important and recent report by SOMO called Powering Injustice. And with that report, SOMO has very gracefully noted the complicity of the energy industry with the Israeli occupation. And noted that states have the obligation, and as well as corporations have the obligation not to contribute to or benefit from the Israeli energy industry. And on that note, also just to now we are at the stage of Q&A, and I'd like to address both of our speakers, and sadly Jinan has just noted to us that she won't be able to join us for the Q&A, but I'm sure our speakers are very well equipped to answer the same questions, and also we have other people here who are very well aware of third state responsibility. But the questions are a bit general. And we have only a few minutes to answer them before I open the ground, but also they do cover some of the larger themes posed by the Q&A. So first of all is generally further elaborating on state obligation towards taking these mechanisms forward, the unseating and the anti-apartheid mechanisms. What are we expecting here from states, and how can we see local actors pushing their own states to undertake their international responsibility? And perhaps this comes hand in hand with a larger question, which is, from your own experience, why are we not seeing these responsibilities going forward? And how do you believe we can overcome that? I know that's a bit of a complex question that includes some speculation, but I believe that for a general audience, it is perhaps good to call things by their name, and perhaps good to instate that. And last but not least, and I apologize for the flow of questions, please feel free to pick and choose. Are these state responsibilities preconditioned on negotiations, as alluded by some actors involved in the subject matter? And is it that we first have to negotiate them, or is it that we move forward with them? I hope that's not a lot. Perhaps if 3 to 4 minutes each, if that is possible, and perhaps if we can start with Maryam, if that's possible for you.
Sure. So, on the point of unseating, the Credentials Committee did actually present its report to the General Assembly under its rules of procedure with respect to the credentials of state delegations for the 79th session. And that report was adopted by the General Assembly in early December without amendment. I think the only comment was made by Iran, and it had absolutely nothing to do with challenging the credentials of Israel's state delegation, but rather was about noting that Iran's vote in favor of the report was not meant to suggest that it recognized the state of Israel. So, which, frankly, I found somewhat surprising, especially from the Iranians. But I would also say that there are perhaps some geopolitical concerns that the Iranians have that outweigh their desire to take a stand on this issue right now. There's also a move apparently being led by Malaysia. I've seen news reports about to actually bring to the Security Council a measure to expel Israel under the UN Charter, Article 6, which again, I think is surprising, at least given the probabilities of success at the Security Council. I understand the sort of demonstration impact and effect of a move like that. And Israel will, of course, be very, very upset about any effort at all to take a move of that nature at the Security Council, even though it knows full well that it will not be expelled. So, it seems like the dynamics right now on this issue, at least, are such that states are perhaps willing to take symbolic action that may not have any actual practical impact, because I do think that the unseating effort would have more practical impact, have a greater likelihood of generating something along the lines of an unseating of Israel, and would place within the General Assembly itself, right, the responsibility for making that decision. So states couldn't say, oh, but it was the Security Council, it was the United States, it was the P5 that vetoed something. No, the responsibility would then be on them for their vote, right? And I think that states are not willing to take on that responsibility yet, which is quite unfortunate and obviously very upsetting. Why aren't they willing to take on that responsibility? Certainly Israel is an unhinged, unpredictable, and dangerous actor. But, in terms of its global influence, its global impact, any global influence or impact it has, it derives from the United States. The United States, in my view, is the reason why states may not be willing to take more direct measures to unseat Israel at the General Assembly, specifically coercion from the United States. There's also there are two pieces of evidence here. There is a bill, which I will admit I have not actually read yet, but there is a bill pending I think it was introduced in the Senate. I'm not entirely sure. It may have been introduced in the House. Basically tying, and there's also other existing legislation in the United States that's sort of on this issue as well, effectively saying something along the lines of the United States will pull its funding from the UN, right, if any punitive measures are taken against Israel. So that's the sort of general, very clear existing approach the US is taking and has taken with respect to any measures by the UN as a body directed at Israel, directed at its expulsion, suspension, some kind of punitive action, right? But then we also see very, very, very clearly with respect to Ireland at the moment, US pressure on the Irish government not to pass the Occupied Territories Bill. And the Occupied Territories Bill, which has been pending in the Irish Parliament for several years, would effectively make it illegal to import goods or services from occupied territories into Ireland. And what the US ambassador to Ireland has said to Ireland is, you better be careful, because if you do this, the 1,000+ US companies that you depend upon for your GDP, because Ireland is very dependent upon the presence of a lot of US companies in Ireland, may not be able to operate in Ireland anymore, because you will effectively be instantiating a boycott, a foreign boycott, which under existing US law, US entities cannot comply with, where that boycott is against a ally of the United States. This law goes back several decades, and I believe it was effectively a response to the Arab boycott against Israel in the 1970s. So I think states are very concerned about the way the United States will respond to any measure to punish Israel at the UN, or with respect to within the individual states themselves. And there was also, I read recently, an investigation launched by the Biden administration against Spain, based on reports that Spain had prevented certain ships from docking in their country because those ships were carrying, I believe, weapons, something of that kind, to Israel. The Biden administration launched an investigation against Spain for what was effectively a measure of compliance with Spain's international legal obligations.
Thank you so much for that, Maryam. And on that note, actually, we recall the importance of third world states and global South states solidarity at the moment, as we face this ultimate weight of the US. And if states of the global South were to have a united policy, let's say, in order to evade what the US is seeking to do, which, as you clearly described, is coercion. And if we are functioning on an international legal system where the premise is state consent, then the fact that there is an actor that is coercing other actors in order not to engage their own state will, then the US, what is the US is doing by protecting Israel is putting the international legal system as a whole at stake, because at the moment, what we see is it threatening the functionality of the system as a whole. And of course, as we can see, the US's efforts has facilitated Israeli impunity, not only in Palestine, but also in Lebanon, and as we see at the moment in Syria, where it has undertaken the most unlawful acts of aggression against the Syrian state. On that note, Victor, would you like to come to these questions? But I will have to warn you with the time constraints.
No worries. I'll be quick. Thanks, Shahad. So I just wanted to pick up on what Maryam was saying about the issue of credentials. She actually raised it, the domestic US law, because I recall, so it might end up with a question which you might want to come back to, that during the Reagan administration, during the war in Lebanon in 1982, I believe the government of Iran actually tried to do exactly what you are suggesting, and it's been a while since I read up on this, but my recollection is that the Reagan administration passed laws doing exactly what you said, mandatory cuts, no funding to the United Nations. So my question was basically, how do you get around the reality of that? But let me come back to what you were saying, Shahad, about the global South, and I think it's and what states can do. And I think it's telling that that there is support. So I think we've got to be a bit positive. There is support for a new global anti-apartheid movement against Israel, and we can see that in the number of states that made written and oral submissions to the International Court of Justice and raised the argument that Israel was acting contrary to the prohibition of apartheid in international law. I think about 24 states explicitly made that argument at the ICJ. Of course, it includes South Africa, Namibia, and Qatar. And all three of these states went further than that. And then their written statements actually said that they wanted to look into establishing a new anti-apartheid committee modeled on the one that was created to combat apartheid in South Africa. And I also noted that the United Nations General Assembly resolution welcoming the advisory opinion, when it called on the Secretary General to look at these mechanisms, also referred to states with experience on these matters, which I think was a vague reference to South Africa and Namibia. So I think there is movement happening on these issues behind the scenes, and we may see some developments in the coming months. It remains to be seen what they can do, but I think states they're moving slowly. Even the UK hasn't done enough, no way near enough, but it has revoked a few licenses, and there's pressure there. There's the ability for civil society to go and say, oh, this is not enough. You've got to do more. And I think that they may be prone to those arguments. I've got a word also on the ICC, if I may, and ensuring compliance with arrest warrants. And the prosecutor has also hinted that they're looking at other officials. So we know, for instance, that they've issued warrants for Prime Minister Netanyahu and the former defense minister. But he's also hinted at potentially warrants against other officials who may not have immunities. Because I think there was a question about universal jurisdiction, and there was a question I think Jinan raised about non-state parties. What are their obligations if Israelis were to travel? I mean, the difficulty there, of course, if Israel, which is not a party to the Rome Statute, travels to another territory that's not party to the Rome Statute, then Netanyahu, for example, could say, "I have state immunity. I'm a head of state." But this might not be the case for if the prosecutor goes for Israeli officials who don't have immunity, for people, for example, involved in the settlement, ministers involved in settlements, for instance. So I think there may be, again, I mean, the wheels of justice move slowly in the international system, but it seems to me that there is a convergence of interests, and there is movement to hold Israelis, I should say, accountable for their crimes. There is movement on this, and I think maybe in the new year we will see some of these developments coming to fruition.
Thank you so much for that, Victor. So I'll start with a question for Maryam. So Maryam, does Article 6 actually require approval of the UN Security Council to expel? All it requires is a recommendation. Article 6 doesn't specify which way the recommendation goes. Could Article 6 mean that the UN General Assembly must give to the UN Security Council an opportunity to give its opinion, but the UN General Assembly has the power to expel regardless of the view of the UN Security Council? Could recommendation in Article 5 similarly mean only that the UN Security Council should state its view, but that its view is not determinative?
I appreciate the effort at reading the language in a very lawyerly way to try and get around the potential requirement for Security Council approval. There is a ICJ opinion from, I believe, 1950 or the late 40s that talked about the sort of relationship between the General Assembly and the Security Council. And again, I haven't looked at this in a while, so don't quote me on this, but the general takeaway is that this opinion looked at the relationship between the General Assembly and the Security Council with respect to admission of states. So in other words, could the General Assembly simply admit a state without the Security Council's approval for that? And again, this is a provision of the UN Charter as well. And what the court effectively held was that the way in which that effectively what the provision required was Security Council approval before the General Assembly could admit a state. And the argument that has been made, and frankly, I think it is a strong one, I don't think you can get around this, is that that opinion on that particular provision also applies to expulsion and suspension. And there have been those, in addition to the person who asked the question, who have tried to argue that no, it doesn't necessarily require that the Security Council approve the expulsion or suspension, that the General Assembly could move on this on their own. I would say, one, I don't know of any General Assembly practice where the General Assembly has actually itself interpreted Article 5 or 6 as not requiring the approval of the Security Council. Specifically in the situation of South Africa, we had a separate effort by the General Assembly to unseat the South Africans, and an effort by the General Assembly to go to the Security Council to request expulsion of South Africa, which the Security Council denied on the veto of 3 states. And the General Assembly was not happy about it at all, and moved forward with unseating. But they were very clear in their understanding that expulsion and suspension was the purview of the Security Council. I think it is very hard, and I think it will be very hard to convince states that the charter allows for the General Assembly to expel or suspend on its own without Security Council approval. And frankly, I don't know that in our current political environment, it matters. If the Security Council isn't willing to unseat Israel based on its own authorities, right? Why in the world would it be willing to expel or suspend? Do you see what I'm saying? Like, from a practical standpoint, I don't really know that it matters. I will say, I'll admit to this. I mean, I do think that Article 5 and 6 are totally separate authorities from the credentialing power. And I think the credentialing power relies on a different logic, the logic of representativeness, the question of legitimacy, not on whether or not Israel is in compliance with UN resolutions, whether it has violated the charter. And I think it's important we keep those things separate.
So there is a question on, there are multiple questions. Let's just put them in one bundle. Sorry, did I interrupt you?
Sorry, so what I was going to say was that while they are separate powers with separate logics, they effectively have the same consequence. If Israel is unseated from the General Assembly, it loses the vast majority of its privileges to operate in the UN. It doesn't lose all of them, but it loses a lot, which is part of the critique of the unseating power, that it is effectively the same as expulsion or suspension, that it effectively is an end run around expulsion and suspension because it is so dramatic in terms of its consequences on a state. So I don't actually think we need to argue over whether or not Article 5 and 6 require Security Council approval or not. I think that they do. I think the practice of the UN is also clear on that point, because the credentialing process is already quite powerful.
Thank you so much for that, Maryam. And indeed, in light of everything that we are seeing, it is quite astonishing that this still hasn't happened yet. So a very general question to both of you, which kind of tries to bundle a number of questions. And I think people are anxious to ask the question of how can this be taken forward? So, and more generally in relation to third state responsibility. So perhaps what role do you see for the civil society actors generally engaging with international mechanisms, but also internally seeking to engage things like universal jurisdiction and the like? So I'm presuming this is a larger question outside of the simply just the apartheid and the unseating, but rather a general third state responsibility. Victor, would you be able to take that forward?
I'll do my best. It's a difficult one. I mean, there is obviously a role for civil society to constantly make the case. There are also initiatives in various countries, not just universal jurisdiction, but also bringing cases under the UN Arms Trade Treaty and arguing that, especially in light of allegations that Israel's committing the crime of genocide, that supply of weapons breaches those obligations, and these are currently before the UK courts. I think the Dutch Supreme Court is still looking at the issue of F-35 fighter jets, spare parts for F-35 fighter jets, and I understand there are similar initiatives in the United States and elsewhere. So I guess you've got to keep up the pressure, but it is. I mean, it is astonishing that states that despite these huge violations, one has to go to the courts all the time, and one can't make a moral argument or a political argument, or they don't seem to carry purchase. There's a clear double standards. Israel's seen as a state that's part of the Western Hemisphere, and we all know this, right? Countries that are on the wrong side are treated differently to those who are considered close to the West, and I don't have answers except to keep pushing, keep trying, keep making the arguments, keep haranguing your representatives to make changes. What else can we do?
So there were questions in relation to arms embargoes also. Maryam, would you like to elaborate on the same question?
About civil society?
And yeah, anything forward that you would advise in terms of taking third state responsibility forward, either internationally or nationally?
Yeah, so I put a link to the advisory opinion that I was referring to from 1950 that interprets another UN Charter article on admission of states that has similar language upon recommendation of the Security Council, where the court said that the Security Council that met Security Council approval. In terms of civil society, certainly I think civil society is important everywhere. To take the Irish example as a case in point, the Occupied Territories Bill, it would be an incredibly momentous development if a European state were to have this kind of legislation. But of course, there's a lot of pressure from the United States, as I mentioned. At the same time, there's massive support in Ireland for Palestine. Far more, people in Ireland want far more than the Occupied Territories Bill. They want a lot. The push from civil society in Ireland is what has kept that bill alive. And in fact, in the recent Irish elections, parties made explicit commitments to move that bill forward. As I mentioned, it had stalled. And according to some Irish activists, they believe that Israel's recent announcement that it's pulling its embassy from Ireland is in part a response to the Occupied Territories Bill and the renewed energy behind that bill. So the only way I see to actually be able to push back against the coercion of the United States, the extreme illegality and tremendously bad behavior by Israel is civil society pressure on states. The civil society pressure on the United Nations, but especially civil society pressure on states. And in places like the United States in particular, where so much of US power, not only US power, but US law has been designed to protect Israel from the federal law that prevents US nationals from participating in foreign boycotts against allies, to state level laws that prohibit BDS, that prohibit individuals from contracting with states if they engage in BDS, to all sorts of other laws, to the UN focused law that both Victor and I mentioned, to current pending legislation, to all sorts of other laws. There are so many US laws that specifically protect Israel and ensure its impunity. Civil society action in the United States, certainly to prevent new laws from being established, but also to unravel existing laws, is crucial. Literally, it is illegal in the United States for private parties to engage in the kinds of arms embargoes, like to refuse, for example, to provide military weapons. If Lockheed Martin, for example, refuses to provide military weapons to Israel, it will be in violation of Colorado's anti-BDS law in all likelihood, and will not be able to contract with the state of Colorado. You need civil society pressure to pressure these companies to take those moves, and to pressure states and state and federal governments to unwind existing laws and prevent other laws from being passed in the future. Now, of course, it's a long road. It's an incredibly long road, but it has been very effective, at least in the last year here, at least in terms of shifting the narrative, which is obviously the first step around all this stuff. The continued effort, though, to build civil society pressure to go beyond the narrative, right, point to more concrete material actions is crucial. And how do you do that? I mean, it's going to depend on your locality. It's going to depend on so many different factors. But this is the time for civil society to ramp up its activities, not wait for states to lead the way, not wait for multinationals to lead the way, not wait for the United Nations to lead the way. This is a if we are going to achieve anything, it is going to come from the grassroots, 100%.
Thank you for that, Maryam. And indeed, in this moment of despair, and in this moment where we have seen an ongoing genocide go on for over 1 year and 4 months, which has been a big challenge to the world. Before I move on to my last question, which will be a very brief call for a very brief remark on both of your ends, there were some questions in relation to arms embargoes, and it is indeed as assured by our speakers that states do indeed have a duty to impose an arms embargo in Israel based on not only their state responsibilities from the ICJ decision we're discussing today, but also from the case of South Africa versus Israel, which calls for the state duty to prevent genocide, and by that undertake all efforts. States have to undertake all efforts within their influence in order to stop Israel against undertaking irreparable damage against the Palestinian people. And sadly, what we have seen now is that the Palestinian people are suffering from that irreparable damage to points that we haven't seen since the Second World War. And indeed is very traumatizing for all of us. And to recall Maryam's words, while this is a very dark moment, this is not a moment where any of us have the privilege of despair, but rather a moment where we need to have higher hope in organizing and in shaping the narrative in a way that upholds some logic. And this is indeed the moment where we should stand next to each other. And so let's leave on this general question, which seeks to in my humble attempt to summarize the questions. What role do you see for international law moving forward? And what do you think this has done for international law? I think I know this is a very big question, but I'm sure this is a question that a lot of our listeners are asking themselves at the moment. So perhaps if briefly, I'm sure you've been going on and on about this recently. And Victor, if you may.
I mean, it looks like the system, as you've said, is unraveling. You know, the total double standards. We've seen that with the arrest warrants. You know, when it's issued against Putin, they should be respected, and when it's issued against Netanyahu, countries like France come out and say that they're not going to. I mean, that might have just been domestic politics. We'll see. But again, I mean, we have to work with a system that we have. I mean, if we look again at South Africa, I mean, the first call for an arms embargo with a resolution in a non-binding resolution in the United Nations General Assembly in the 1960s, and then eventually that cascaded into a binding resolution. So it might be a question of, and the importance of states is that they have the ability and the power to impose embargoes beyond what we can do as civil society. So it may be, again, just simply focusing on more creative ways, pushing the envelope, making new arguments, and trying to seek to hold Israel accountable in the very difficult circumstances that the world is facing.
Thank you, Victor. And Maryam?
Especially now that we have this important guest that has joined us. You know, I don't generally subscribe to the view that the enemy of my enemy is my friend, but I think in this context, it's quite illuminating as a concept. Israel and the United States don't want international law to play a role when it comes to Palestine. They want it to be politics and power, as Shah had mentioned. And so in light of that, I think we should embrace and redouble our efforts to promote and emphasize the importance of international law. International law is far from perfect. It has a very problematic historical origin story, right? Very problematic applications throughout history, riddled with double standards, both in its application and in its conceptual basis in many ways. However, it is also and has been a tool of liberation. It's been a tool that has helped protect and promote and lift up the interests of those who are the most vulnerable. It was a crucial component of decolonization, right? The UN was important. The very nature of the UN shifted as a result of decolonization. The very nature of international law in many ways shifted because of decolonization. And we have now had decades of reformation of certain concepts such that they are now dangerous to actors like Israel and the United States. So I'm not here to say, oh, international law is going to save us or resolve this situation. It's absolutely not going to do that on its own, but it is still something that we, as those who want to see accountability for Israel, who want to see freedom for the Palestinians, we should embrace it. We should understand its limitations, but we should also understand its power, and we should leverage that power.
Thank you very much for that, Maryam. And indeed, it is indeed it is a strategic tool. And as you said, reading international law in a harmonized reading with an eye to the history that international law has played in the decolonization movement, recalling those instruments, and indeed framing the case of Palestinian self-determination as decolonization, building on the strength that that language gives us in our advocacy, and also in challenging state policies that have the label of humanity in front of them while partaking in the most violent of acts, calling upon the hypocrisy of an international legal system that has that mask of humanity while showing us its worst face, as seen in the extreme case of Palestine. Indeed, Palestine is emblematic of a lot of what is happening in the larger global South and in the neo-colonial world that we live in. And indeed, this is a moment for us to think together in how we can uphold some symbol of justice in this world. I thank you both for your time, and I thank our attendees who have endured 5 minutes extra with us. I apologize a lot for my relaxed timekeeping. Thank you very much, and I hope this has been a fruitful discussion that will help you reflect on how we can engage with these mechanisms, and hopefully as we work together, the only accountability for the Palestinian people at the moment starts with liberation and decolonization, and we hope to see it in our lifetime and with our joint efforts. I thank Law for Palestine for hosting this. Thank you guys very much, and hopefully we see you in our future events, and please keep a lookout for our newsletter. Thank you very much.
Thank you, Shahad. Thank you, Law
Thank
for
you
Palestine.
so much. Thank you, Law for Palestine. Thank you, everybody.